Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm joined by my co-host, Justin Williams, and we're here to help you make the most of your minerals and royalties. And in this episode, we're going to cover the latest mineral rights and energy news for September of 2025. Justin, it's almost the end of the year. This year has gone by way too fast.
It sure has, Matt. It seems that the years are just flying by, and there's a lot to talk about.
Yeah, like we were talking before we hit record, there are a lot of very impactful news articles out there this month related to minerals and royalties, and some that will have a lasting impact in terms of case law and the things that have been in the news around produced water, around things like dormant minerals. And so, Justin, let's dive into that first article.
Let's do it, Matt. So the first one here is for North Dakota. North Dakota mineral right owners say oil companies unfairly keep millions from checks without oversight. Matt, it goes on to say that mineral owners in North Dakota often see 20 to 35% deductions from their royalty checks without clear explanation. And there were some legislative changes that happened in 2009 that kind of set the precedents. And we were talking a bit before we hit record, Matt, about the precedents being set that the royalty should be calculated at the well, which is a somewhat confusing statement, which means they can charge back deductions for transporting. On the opposite side of that, free of cost is what you would see if you weren't able to be charged deductions. And it seems like their increase has just been really great since that ruling over the years. The article mentions that 2015 is when they kind of looked at the data and saw the huge increase in deductions. But yeah, it would make me unhappy too, Matt.
You know, this is, I wouldn't call it so much a hit piece, in terms of diving deep into this topic, because they're really, had some disgruntled royalty owners, and they, are trying to get to the bottom of like what's going on around post-production deductions. And this is not like a secret, right? This is something that is pretty well known in the industry, that you need to protect yourself when you sign an oil and gas lease. And this is, I guess, a cautionary tale, I'll say, because certain states have some protection for mineral and royalty owners when it comes to prohibiting the amount that operators can deduct from royalty payments. And that is primarily around the natural gas. And so it's expensive, it's time consuming. There's lots of steps involved with getting gas in its raw form from the wellhead through a gas plant into a form where it can be sold as natural gas. There are very specific requirements in order for something to be called natural gas. It has certain limits of, as far as the heating factor, the BTU value, the different makeup of the different substances that are in it, et cetera. And so there's a series of processes that it needs to go through to strip out any natural gas liquids so that those can be sold and you can receive value for those, and then that the natural gas can be sold as natural gas. And so that's a pretty well-known situation. It's in some cases, it's unavoidable if you have a very old oil and gas lease that does not limit post-production deductions, and you're in one of those states, like North Dakota, for example, or Texas, or some of these other states that are, maybe silent to those post-production deductions or allow operators to subtract those from your royalty payments. And it stings when you look at your royalty payment and you see that your natural gas deductions are 30% of the value off of that natural gas, because they had to take things off for compression, for marketing, for transportation, processing, all those things to, again, do all the things that I mentioned to get the gas into a saleable form. And so this article just really talks about the specifics related to North Dakota and some examples of mineral and royalty owners that have been affected by this, and it gives some numbers as to the impact on one family. And, this Diana Scarpole, they mention in here some specifics that she noticed about 35% of her expected payment had been deducted in terms of those post-production deductions. And so if you're in the situation where you do have a substantial amount of post-production deductions, it's a good idea to go through and check your lease, read the language. If you need help from an attorney to interpret that, that's a good idea. Maybe it's an hour or two of their time to help make sure that they can say, yeah, okay, the operator is doing what they're allowed. Unfortunately, you have to bear those proportional share of those costs. Or they might say, oh, wait, no, hold on a second. Your lease limits that, and they're incorrectly taking that out. And in which case you can go after the operator, notify them to get reimbursed for that underpayment and any interest. And then, in cases where operators chronically, don't follow the language in the lease and are incorrectly taking out post-production deductions, there have been many successful class action lawsuits against oil companies where operators have gotten together and gone after that and gotten, successfully, sued the operator and got reimbursed for those underpayments. And so there's a whole series of things you can do. And, this talks about some specifics related to, they mentioned a Hess, this Iverson family versus Hess Corporation from 2021 for $10 billion in damages. So that's one of those lawsuits that was out there that they tried to go after Hess. But yeah, I think the real takeaway here is be very careful when you sign a new lease. And that's why we always recommend you try to get language included in the lease that limits the amount that an operator can deduct in terms of those post-production costs. We call that a cost-free lease, and there's specific language you can use, working with your attorney to protect yourself so that those deductions don't creep up over time and eat up a lot of the royalty payments that you would be receiving. And sometimes that means a trade-off between a slightly lower royalty rate in order to get that kind of language included. But again, it's something highly recommended to get with an attorney when you are signing a lease, just because it can last for decades after the time when you sign it. And that kind of language can make a big difference in the amount that you actually get paid at the end of the day. And so I think this is just a great reminder of that. And if you're in a state like North Dakota that is ruled maybe in favor of operators being able to allow those deductions or deduct those costs from your check, unless your language is explicit in your lease that prohibits it. And then, I think one of the other things that I thought was interesting, I mentioned some other states, for example, states where there are more protections that, prohibit some of those costs being passed on to the royalty owners. And West Virginia was named in there, Colorado and Kansas. They mentioned also Oklahoma. I know that Oklahoma has many protections and statutes that are favorable to mineral and royalty owners, but I do believe there is some level of requirement to include language in there that limits some of those costs. And it depends on the type of interest. I have some overrides in Oklahoma that they deduct quite a bit in terms of those post-production deductions from my gas royalties. So yeah, your mileage may vary, but again, if you have questions, get with your attorney, I think is the moral of the story, and good lesson.
Yeah, you said it, Matt. And really, it seems like what they're looking for in North Dakota is for legislation to step in and set some limits like some of the other states have done. And maybe North Dakota will end up doing that. This is a good example too, Matt, of how law really shakes out. It ends up in private courts with battles over private assets and private funds. And then if there's enough, the legislation may review it and may pass changes. But North Dakota doesn't seem to be all that interested at this point. But again, the winds may change there. All right, Matt. So our next one here is for Wyoming. Wyoming weighs a bill to give abandoned mineral rights back to landowners. So this is an interesting, Matt. Lawmakers are proposing to let landowners reclaim long abandoned mineral estates, resolving tangled ownership dating to the homesteading era and protecting the rights of property owners. And Matt, there's some other states that operate this way. And Wyoming is not currently one of those. So essentially, there would be a process where they could reclaim the property, and this would or default back to the surface estate. Is that right, Matt? Or would it need to be a process of reclaiming that anyways?
Yeah, I think they're still working through the language. And that bill, I guess, is still being drafted or being finalized. I'm not sure exactly how it's going to shake out, but the gist of it is that, for long abandoned mineral rights. So let's say if you're in the situation where you had an ancestor that maybe was one of those people that homesteaded the land and, retained minerals when they sold the farm. It's been passed down over the generations, but maybe it's been, hasn't been producing. It maybe got forgotten about, didn't get passed on and go through probate and get titled to the heirs. What it would mean is that if this statute passes, there would be a process for the surface owner to reclaim those abandoned, quote unquote, abandoned mineral rights. I have a problem with this, I think, because it's private property, right? It's something that somebody has explicitly decided to do to reserve that property and retain it for their family. And, maybe they didn't go through the process of putting it in a trust or an LLC, and so that it would ease the process of getting handed down to the future generations. So maybe it's still sitting in their name out there, and they passed away a long time ago. There hasn't been production until now. There's interest in it. There's a lot of value there that is potentially going to be rug pulled from those private mineral owners and given to the surface owners. There is a lot of lobbying going on here. It looks like the Wyoming Farm Bureau is mentioned in here. It mentions the Oil and Gas Association, Wyoming Mining Association, Stock Growers Association. So basically the organizations that are going to benefit from if this law passes. So obviously generally the stock growers, the Farm Bureau represent the surface owners, the current farmers and ranchers, which play a valuable role in the economy in Wyoming and other states, and sometimes don't have the minerals. Again, if they purchase the farm after the minerals have been severed, or maybe they only own a portion of them. And then, of course, the operators, it makes their job a heck of a lot easier. They don't have to do that complex title work, because if the surface owners have the minerals, then they're dealing with kind of one party, perhaps to get a surface location and to get a lease. So it makes their job easier. One thing I think that we need to step up as mineral and royalty owners and let our voices be heard on this particular issue, so they understand the full implications of, taking those private property rights. Because ultimately, if there's no value given, that, in my mind, that becomes a taking without due compensation, which is a violation of the Fifth Amendment to the Constitution. So I see a problem with this. And I've always kind of had issue, I guess, or maybe just felt maybe a little bit uncomfortable with those dormant mineral statutes that have the potential for taking away that property. Now, some of those have been in law for a long time, but it's really no different situation.
You said it, Matt. And the article kind of mentions that there's some talk about modeling the way that North Dakota handles this, which I'm not aware of the way that is, Matt. But like you said, it's going to be interesting to see the mechanism that they use for this, if they're going to move forward with this. And it could create a lot of confusion. And they're talking about basically the fragmentation of the minerals being a huge problem and able to find those people. But that's a problem that's shared across multiple states. I mean, if you ask somebody in Texas, I don't think they'd have a lot of a landman in Texas certainly wouldn't have any forgiveness for a landman in North Dakota for having to go through all of the different splits through the heirs to the years. So this is a process that is already handled in the oil and gas industry. Not sure what caused this in Wyoming, but they are saying that the split estate problem, as they call it, has been a problem for a long time. And Matt, it'll be curious to see what the argument really is for that and why you would pull that value away.
To your point, it's ultimately those that are going to benefit from it that are proposing this bill and that are supporting it. So, I think, again, it's just something where we just have to let our voices be heard, and so they can see the bigger picture and how it's, maybe benefiting some of those more vocal stakeholders right now. It's also, if we're vocal as well and saying, hey, we're not in favor of this, it's going to be taking away our private property without compensation, expect to get, into a legal battle. And that's sort of what they alluded to here, is that when you talk about, the dormant minerals or the split estate with minerals, that it's like touching the third rail and then lawyers come out of the woodwork. And I do think that is going to happen if this moves forward. So yeah, it'll be very interesting to follow this and see, what kind of language gets included in there to make it a fair bill for all parties. So we'll see what happens.
You said it, man. And another one here about ownership. So this has been something that everybody has been waiting for someone to talk about in Texas. And so oil companies want to sell their wastewater. The Texas Supreme Court decides who gets the profits. So, Matt, there was a case which occurred between Cactus Water Services and COG Operating. And essentially the court ruled that mineral owners, not surface landowners, own the produced water from the oil and gas drilling. And this is a huge decision here, Matt, because there's been a lot of talk with lithium and other minerals that might be extracted. And this is kind of a fundamental decision that had to occur before it could really move forward. It's always been assumed, Matt, that the wastewater was owned by the operator, but this is because it's always been seen as a burden and a cost to dispose of this. And now that there's value found in it, it's kind of shaking the waters here.
Yeah, and I think it solidifies that, which is kind of, like Justin mentioned, has been the case for some time, that custody of produced water goes to the lessee, goes to the oil company, in other words. And then that basically was done so that they can be held accountable for properly disposing of it. So because produced water has always historically been a pretty large cost and expense in oil and gas production, it's been something that they were just having to deal with, right? So it's okay, you have to deal with the produced water because it comes from the mineral estate. You're the lessee that was conveyed to you when you took that lease. And this really solidifies that as the precedent, or kind of reinforces it, that the produced water, because it conveys to the lessee, then by virtue of that, it was originally part of the mineral estate. The thing that it did not do, because just because of the nuances or the specifics of this case, that the only thing that was mentioned in there was oil, gas, and other hydrocarbons. It didn't mention other minerals. So it's silent to, I think, who has the lithium in the produced water, for example, or other valuable substances. So it unfortunately does not clarify that, but it did, from the standpoint of any hydrocarbons, whether it's oil, gas, or other oil, gas, and other hydrocarbons was the language in the leases in question. It really solidifies the ownership of that produced water and the responsibility for that. But the thing that it does not do is address who benefits from the lithium that's produced. And does it mean that you have to explicitly reserve the lithium and other minerals in order to benefit from those and to be able to lease them again in the future? Or, if you're silent, does that mean you're conveying those rights as part of that lease? So all of these questions still remain in Texas, at least, because that's where this case was, as to what and who benefits from lithium production, which is becoming a big deal in Northeast Texas, because right on there on the border, with Louisiana and Arkansas, where there's a big rush in the Smackover Formation to produce lithium and to benefit from it, from direct lithium extraction, which we've talked about a lot on the show. But, I think it's going to be, again, for now, there's going to be more lawsuits, I think, that come up around lithium and who gets what, and and really clarifying that, because that needs to be either put into law or there needs to be some case law to decide, clarify who gets what in terms of the lithium. But for now, I think this was a pretty landmark case from a produced water standpoint and ownership of that, and the oil and gas within that produced water and who owns what. Because there was some question, does the water belong to the surface owner? Because that's kind of historically where the water has resided with. But in this case, no, that they said this is because it's part of the formation that you're producing it from. And, with the oil and gas that's in there in that pore space in the rock. And that's kind of what they decided. So yeah, interesting case. And this happened, a couple of months ago, and we should have covered it sooner, but it's definitely been an important one to pay attention to if you have minerals in Texas.
You said it, Matt, and they've talked, this has been a topic that's been talked about a lot in Texas, and a lot of folks asking for the RCC to clarify some things when it comes to not only wastewater, but also the ownership of the lithium and other minerals in the wastewater. So it'd be interesting to see that we still anticipate the Texas RCC to say something to provide some clarification, though I'm sure they have to do this very carefully.
Yeah, you're absolutely right. So yeah, and then the last one here, we'll just highlight just an update. We've talked about this particular case decision in North Dakota. This is another North Dakota article. It's lawsuit questions mineral rights transfer under Lake Sacagawea. And, this thing is like a saga, like we've talked about. This has been going on since 2017 when Senate Bill 2134, when they decided basically who gets what. And there's like this whole thing about this Lake Sacagawea. There's a high water mark. Where's the boundary between the private mineral owners and then the state and the reservation in terms of the different tribes that are there? And so they clarified that. Of course, it's been several things that have been argued at the state Supreme Court level, and they've kind of left it to that previous high water mark. Now they're coming back, and it's interesting that we were talking before we hit record that it's strange that this suit, which was filed by former gubernatorial candidates Michael Coachman, Marvin Nelson, and Paul Sorum, it questions that, and it's a quiet title suit, which in my mind, when I've dealt with quiet title filings, it's related to those that have an interest in that property. It's curious that these guys are getting involved in this quiet title suit. We talked about there is got to be some money behind this, and they're acting on behalf of whoever is behind this, really, and who will benefit from, if this was reversed. So kind of a strange one from that standpoint, because those that are the plaintiffs don't seem to have a financial interest in this directly. So there's got to be some indirect financial interest that they have, which when there's those kind of backroom dealings going on, you kind of question the integrity of the whole process. But interesting one that this has popped up again.
Yeah, you said it, Matt. This has just been, like you said, really ongoing. It'll be interesting to see kind of what plays out. And the big question mark is that there's this belief that the relinquishing of this right created some kind of chain of title problem, I suppose. And that's kind of how they're going into this. But like you said, Matt, there's not a lot of information coming out. The fact that it's done quietly, it seems to be backroom dealings. It'll be interesting to see how it shakes out, because I'm not sure how a court would have left the chain of title unclear. Yeah, interesting.
Yeah, more to come here. I guess this one's not over yet. So we'll keep you updated as we learn more about this ongoing litigation. So, all
right, Matt, last but not least is our rig count. So it looks like we're pretty darn flat here.
Yeah, it's pretty flat, and I wonder if we maybe are bottoming out. It seems like the rig count has sort of steadily started to stabilize. We're at 523 rigs, land rigs, for the week of August 22nd, and that's down one rig from the previous week, and then down 43 rigs from a year ago. So a year ago, we were at 566 rigs. So looks like we just had some small adjustments. So North Dakota dropped a rig, Louisiana added 2, Texas lost 2. So it seems to me that there's a little bit of a shuffling around the gas rigs that are running right now, perhaps from the Texas side of the Haynesville over to the Louisiana side. And that's just kind of probably where they bounce back and forth there. So nothing substantial. But yeah, I wonder if we've hit the bottom. Hopefully, knock on wood, that we've hit the bottom and it'll sort of stay where it's at or maybe go up.
Yeah, let's hope that we see a trickle up. We talked, I guess, on our last news episode about the big, beautiful bill and some of the energy changes that came into that. Seems to be very pro oil and gas, but doesn't necessarily mean it'll blow the winds in the way of making the operators really go out and invest money. They're going to be looking at this and trying to stay within cash flow. So the time will tell.
Yeah, you're exactly right. And definitely oil prices have been lower than they've been in over, maybe a year or so. We're sitting around $63 a barrel right now. So, don't expect to see any sort of major uptick, but, hopefully we'll see it sort of stabilize out. When you look at it over the last, say month or so, we're down probably about 10% from about a month ago. So it's been a little bit of a roller coaster ride for the second half of this year with the things that have been going on. So, where we entered the year at around, $70 or $72 a barrel, that kind of went up a bit, and then it's sort of kind of been a little bit on a downward slide, but it sort of bottomed out, around that $62, $63 per barrel mark. So hopefully it stays at that level or maybe starts to tick back up. And of course, it always depends on the geopolitics. And then, of course, what happens this winter, around how cold it is and, demand for electricity generation will determine how natural gas does as well. Natural gas right now is sitting around $2.72, which is, again, also down a bit from the beginning of the year, which was, above $3. So, yeah, interesting to see how things will play out. And I think, with gas, you see this time of year, they're starting to build that surplus for the winter. And then once winter starts, the temperature, if it gets really cold, you'll see spikes in natural gas prices, but that's kind of a big driver there. But yeah, from rig count though, from activity level, pretty stable. So yeah, it'd be interesting to see what happens.
You said it, Matt. Yeah, interesting about the news when it comes to mineral owners' ownership. We often hear about oil and gas, but a lot of times it's operator news, acquisition news. These are some really important cases going on for what is it exactly that mineral owners own. Yeah,
very important, impactful case law being decided right now or in the process of being decided. So stay tuned. We'll keep you updated. As always, we'll link to the articles we talked about today. You can find those in the show notes, which are at mineralrightspodcast.com. And if you come across an article that you'd like us to cover, send it to feedback@mineralrightspodcast.com. Thanks again for listening. Thanks, Justin.
Thanks, Matt.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.